Since our last meeting, I've been contacted by a great number of people, over 100. These are frustrated citizens. These people are upset as to the actions you took pertaining to the Second Amendment resolution. Many of these folks are extremely knowledgeable in regard to this issue and simply cannot comprehend why you would not pass a token resolution. Why you failed to send a loud and clear message to the General Assembly and the Governor that any infringements to those inalienable rights guaranteed by the Constitution of Tennessee and the United States would not be tolerated, especially in consideration of the fact that each of you took an oath of office in which you solemnly swore to uphold both. Main part of it. Your actions may be understandable if Carter County was the first and only entity to take such action. However, this same message is being delivered all across the country without delay. For this very issue is being addressed at the federal level. How many of you have had an opportunity to just follow the Judiciary Committee and their actions last week and all the discussions that went on and the proposed bill that our Senator Feinstein has proposed? If you haven't, I encourage you to do so. You need to take a look at what's being discussed. I watched some sections of it just the other day, the proceedings on Thursday, and it was really frustrating because most of these senators were sitting there touting the fact that they had been there 38, 40 plus years, and they knew what was best for the citizens, especially here in Carter County. I mean, come on. The clear majority of these citizens that have talked with me understand nullification and the role of the courts in determining what is or is not constitutional. These people are of the belief that it is the responsibility of their locally elected officials to represent their needs, and if this is done properly on a regular basis, those who legislate at the state and federal level would not consider, or at least they would think twice before they take any actions which would ultimately result in infringement of their individual rights. Actions which often result in lengthy court battles. For, as you well know, even at the local level, but at the federal level, litigation comes with a tremendous cost. And most often, a fair and equitable resolution does not come within one's lifetime. In essence, it's usually a tremendous waste of time, valuable time, and resources. Hear the adage, an ounce of prevention is worth a pound of cure, seems to be most appropriate. To reiterate points made last month, it is very clear that gun control does not work. If it did, Chicago and Washington, D.C. would have no violent crime. In fact, while having some of the strictest gun laws in the United States, both cities have one of the highest murder and robbery rates. There seems to be nothing in the President's unilateral action, a one-size-fits-all solution that will deter criminals, but it will most definitely interfere with law-abiding citizens and their rights within the Second Amendment. Folks, we're missing the point and are in a knee-jerk mode. Guns do not kill, people do. The common element in all of these horrendous tragedies is one of mental illness. The true focus needs to be on how to identify these individuals and do everything possible to secure treatment. People acting through their representatives, the states created a compact. The Constitution, through which they have delegated very limited powers to the federal government. The Constitution is superior to and takes precedence over federal law if the two are in conflict with one another. Thus, as other counties across the country have done, and at the request of countless Carter County citizens, I respectfully resubmit the resolution for consideration. A resolution to preserve and defend the rights of citizens of Carter County to keep and bear arms is granted by the Constitution of the United States of America and the Constitution of the State of Tennessee. Mr. Chairman, at this time, a motion to adopt said resolution is in order.
No, Your Honor, or Mr. Mayor, it is not in order. This was not placed on the agenda. You did not forward it to me to be put on the agenda, as anything else in your report was not forwarded to be placed on the agenda. And only items that are on the agenda, especially a resolution, will be considered.
Mr. Chairman, with all due respect, if any of these commissioners choose to make that motion from the floor, sir, you cannot stop it. You've tried that before. You're operating totally outside your zone of neutrality. As chairman, it's not for you to dictate the policy. It'll be up to these commissioners to decide that, sir.
I'm not dictating policy, Mr. Mayor. I'm simply saying what was already brought up here today. Things are not on the agenda. That's correct. Some things were not forwarded to be put on the agenda. And a resolution is a very worthwhile thing to be put on the agenda because it will bring some comments. This gentleman back here was not allowed to speak because it wasn't on the agenda. If you had forwarded it, it would have been on the agenda.
Sir?
Is that not correct?
Sir, listen, again, as chairman, I've sat there, I know. That's a neutral zone. Sir, you're way outside your scope. If these commissioners decide to make a motion, sir, you cannot prohibit that motion. You can't do it.
Motion.
You're out of order.
Mr. Bird, you mean we can't make a motion from the floor on something?
We have to have an item, especially something as a resolution, to be in our packets for each one of us to have time. And Ms. Brown, you've been on this time and time again to have things in our packet in a timely manner.
Yes, sir, and there's stuff that never gets to our packet that we find on the table when we come in here and sit down.
And that comes usually from the mayor's office.
Not always, sir.
Mr. Lewis.
Thank you, Mr. Chairman. I also have a lot of my people in my district, outside my district. Wonder why if we didn't pass this gun bill last month. And personally, I think it's a good thing for the citizens. And I'm gonna go ahead and make a motion that we accept it.
I already made a motion.
Thank you, sir.
I'll say a second.
The motion is not in order. However, if you all are of the opinion you need to go ahead and do this now and do away with any rules that have been set in the past about things appearing on the agenda and in your packet, then I guess from here on it'll just be helter-skelter what comes up during the meeting.
Well, sir, it's been that way.
No, ma'am.
Yes, it has.
That's your opinion. Mr. Harney.
Mr. Chairman, these resolutions and other things that come before this commission is supposed to be in our packet 5 days prior. And this right here was on my desk whenever I came. It was not in the packet.
Mr. Chairman, this resolution is a sound resolution. It was prepared by our county attorney, not by the mayor. The mayor provided several. Well, I provided one in particular resolution to the county attorney and asked him to draft something that was reasonable. And he did that. And it was in your packet last month. It's not a new issue. You've had it, you've reviewed it. And when I've got 100 citizens as mayor of this county plus that have asked me to do something, I'm going to do it. Because I work for them. They pay my salary.
Let me ask you one more question, Mr. Mayor. Why didn't you put it in their packet?
There's no reason. I'm here representing the people. This is mayoral report. I have an opportunity to address the items that I feel is important to these citizens. I'm a member of this commission. I have every right to address issues that the people have brought before me, sir.
You're an ex officio member of this commission.
Question on the motion.
All right, motion by Mr. Lewis, second by Mr.
I made the
Trigg
motion.
to approve
Make a motion to
the
table.
resolution. Motion to table moved by Mr. Arnie,
Second.
second by Mr. Cutler. Any discussion? There's no discussion on it. Call the roll.
What's this motion on? To
To
table?
table this resolution till our next meeting.
Mr. Chairman,
Sir.
I think if we'll get Attorney Bowers to pull out his copy of Robert's Rules of Order, sir, we use the motion to table to prevent any item that we don't want to address coming up. And I think Robert Rules specifically states that you cannot use the motion to table simply to block legislation or discussion on legislation.
I don't think that's what he meant. I think it's meant to be put on our next agenda, for our next meeting.
Give us some opinion
I'm wide
here.
awake. I'm just shocked by everything.
They,
Attorney, is that not the case? The motion to table cannot be used as a blanket to block any type of discussion and legislation on the floor?
If I'm to become the parliamentarian of the commission, I'll be glad to do so, but I need to take an agenda, I need a copy of Robert's Rules of Order. And I'll be glad to look at it, but I'm just not, I've never had that role. It's never been my duty to be parliamentarian.
Mr. Street,
Are we in discussion, Mr. Chairman?
there's no discussion on
I'll be
the
glad.
table.
It'll just take 5 minutes.
And like I said, this is not a move to block legislation. It's a motion to table it to our next meeting where it can be placed on the agenda in an orderly manner like it's supposed to be. Call the roll.
Buford Peters,
Mr. Chairman, I will amend my motion that we table this till the next commission meeting.
Very well. Call the roll.
Buford Peters,
Aye.
Steve Ritchie, Lawrence Hodge,
Aye.
Nancy Brown.
No.
Joel Street,
Pass.
Richard Winters,
Aye.
Ronnie Trivett,
No.
Harry Sis,
No.
Charles Von Cannon,
No.
Elsie Tester, Steve Lawrence, Tom Bowers,
Aye.
Joanne Blankenship. Pass. Charlie Bailey. Bobby Dees. Pass. Ken Arney,
Aye.
Steve Chambers, John Lewis.
No.
Sandra Coler. Russell Cott,
No.
Scott Sams,
No.
Bill Armstrong,
Aye.
Pat Hicks,
Aye.
Robert Goff. Does anyone want to change their vote? Richard Williams, how'd you vote?
How did you vote?
How'd you vote?
I voted aye.
Eight to eight.
8 to 8. Motion failed. Now, go back to the original motion
Yes.
to,
Accept the
accept
resolution.
this resolution. Call the roll, please.
Buford Peters,
Just a minute. Yes, Mr. Peter.
Can I request that the resolution be read before we vote?
You can.
A resolution to preserve and defend the rights of the citizens of Carter County, Tennessee, to keep and bear arms as granted by the Constitution of the United States of America and the Constitution of the State of Tennessee. Whereas the founders of this great country established a government free of tyrannical rule from England, drafted the Constitution of the United States of America to provide a framework where the citizens of this country could live and prosper free and fear from oppression. And whereas in their wisdom the founders also ensured that certain rights and freedoms would be guaranteed by the citizens or to the citizens of this country, and through the ratification of the first 10 amendments to the United States Constitution, collectively referred to as the Bill of Rights. And whereas the Second Amendment of the Constitution of the United States of America provides a well-regulated militant, be necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. And whereas the United States Supreme Court has interpreted the Constitution of the United States has repeatedly upheld the Second Amendment and the rights of individual citizens of the United States to keep and bear arms. And whereas the drafters of the Constitution of the State of Tennessee also sought to ensure certain freedoms and rights will be guaranteed to the citizens of the state through Article 1 of the Tennessee Constitution, which is known as the Declaration of Rights. Whereas Article 1, Section 26 of the Constitution of the State of Tennessee provides that the citizens of the state have a right to keep and bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. And whereas Article 11, Section 16 of the Constitution of the State of Tennessee provides that the Declaration of Rights hereto prefixed is declared to be part of the Constitution of the state and shall never be violated on any pretense whatsoever. And to guard against the transgression of the high powers we have delegated, we declare that everything in the Bill of Rights contained is accepted of the general powers of government and shall forever remain inviolate. And whereas the President of the United States, Vice President of the United States, and certain members of the United States Congress are reportedly considering taking certain actions, including the proposal and adoption of certain laws and regulations which would infringe upon the rights of the citizens of the United States of America and the State of Tennessee to keep and bear arms as guaranteed to said citizens by virtue of the Second Amendment to the Constitution of the United States and Article 1, Section 26 of the Constitution of the State of Tennessee. And whereas the Commission of Carter County, Tennessee finds it in the best interest of the citizens of Carter County to pass a resolution expressing the disdain of the citizens of Carter County toward these proposed infringements and petitioning the Governor and the General Assembly of the State of Tennessee to take the preventive measures to this matter to ensure the preservation of rights of the citizens of Carter County and Tennessee to keep and bear arms. Now, therefore, be it resolved by the County Commission of Carter County, Tennessee, meeting its regular session on this, the 18th day of March, 2013, and with the lawful quorum of said commission being present with the majority voting in the affirmative, that the County Commission of Carter County, Tennessee, hereby calls upon the Governor and the General Assembly of the great state of Tennessee to immediately pass any acts as may be appropriate to protect, preserve, and defend the rights of the citizens of Carter County and the State of Tennessee guaranteed to them by the Second Amendment of the Constitution of the United States and Article 1, Section 26 of the Constitution of the State of Tennessee to keep and bear arms, and specifically to immediately pass any acts as may be appropriate to nullify an implementation within the State of Tennessee of any federal law, regulation, executive order enacted to restrict the rights of the citizens of Tennessee to keep and bear arms. And be it further resolved that this resolution shall take effect from and hereafter as date of approval, the welfare of the county demanding, and further this resolution shall be transmitted to the clerks of the Senate and the Tennessee House of Representatives, as well as the office of the Governor of the State of Tennessee. This is the 18th day of March, 2013. Chairman.
Since we broke the rules thus far, let's ask the gentleman that wanted to speak on this to come forward and give us his opinion.
Sure. Why not? We throw them out the way. Come on up, sir.
How you doing? My name is Joseph Kowajewski. Yeah, I won't expect you to spell it, but I can give it to you later on. I moved here to Carter County 10 years ago. I moved to Tennessee because it was the volunteer state. If I can get this unfold. 47 years ago, I took an oath to defend and uphold the Constitution. Sorry. I believe that oath had no expiration date. I'm not a lawyer, I'm an amateur historian. And over the last 10 years, I have focused mostly on the founding documents and how they were drawn up and why. Our founding fathers had a fear of government. George Washington said, "Government is not reason. It is not eloquent. It is a force. Like fire, it is dangerous, a dangerous servant, and a fearful master." James Madison, who was the primary author of our Constitution, said, "If men were angels, no government would be necessary." If angels were to govern men, neither external nor internal controls of government would be necessary. That is why the Constitution was written, not to control the population, but to control the government. The Declaration of Independence is the document that establishes a free and independent nation with these words: "When in the course of human events it becomes necessary for one people to dissolve the bounds that have connected them to another, and to assume among the powers of earth the separate and equal station to which the laws of nature and nature's God entitled them." The Declaration also states, whenever any form of government becomes destructive to those ends, it is the right of the people to alter or abolish it. Does this sound as if the framers of our nation believed in the sovereignty of government? The Declaration of Independence is the blueprint for our nation. The Constitution is the owner's manual. If you notice, I never speak of government power. I speak of government authority. The government has no rightful power. It only has the authority which is granted to it by the people. A license which can be revoked at any time. Now for the reference to the Supreme Court that was made in the last meeting. The Constitution does not give the Supreme Court the power to decide what is constitutional. In fact, nowhere in the Constitution does it mention how to decide constitutionality. But it does say that only the states have the authority to amend the Constitution. Therefore, it stands to reason that the authority to determine constitutionality also rests with the states. The Supreme Court early on assumed power to decide constitutional issues, and the other branches never bothered to challenge it. But does it make any sense at all that our founders, who so feared overreaching government, would hand the authority to judge constitutional issues to 9 men who were never elected and who held the jobs for life? I don't think so. Now the Commission, while willing to cede this unholy power to the Supreme Court, also cited Andrew Jackson in a dispute with Clay as an argument against nullification. Is this Commissioner aware that this same Andrew Jackson, when the Supreme Court decided against the constitutionality of moving the Cherokee Nation in Worcester versus Georgia in 1832, made the statement, John Marshall, who was Chief Justice of the Supreme Court, has made his decision, now let him enforce it. And also in the same letter, he wrote, the decision of the Supreme Court has fell stillborn, and they find they cannot coerce Georgia to yield to its mandate. In other words, Georgia nullified the Supreme Court decision, and Jackson stood behind it. When John Adams was president, he passed the Alien Sedition Act, which made criticizing the government a federal crime. The 1797 to 1798 Virginia and Kentucky resolutions were written by Thomas Jefferson and James Madison, and they effectively nullified that act. So I say that not to stand up to the federal government and pass the Second Amendment resolution is an act of abject cowardice. Thank you.
Thank you.
Mr. Chairman,
Good.
I have something to say. I looked at all these people back here, and most of them got signed up there. They all done it. I do. This is just a token. Let them know what we do up here in Carter County, that we're against them trying to take our guns and resolutions. Now, I can see why some of you vote against it. I just don't understand. Well, that's all I have to say, Mr. Burns.
Mr. Ron Cannon.
How many commissioners served? I know Keith Bridges did. I did. Maybe that's part of it. Because we've got folks here that haven't gone through what others have to defend the right to bear arms. I appreciate the history lesson from the gentleman because it was well founded. And there's another fellow that you need to listen to. You need to go back and read Bill Peters' article on bearing arms. This nation was founded with citizen soldiers up until the Civil War. The Tennessee militia required so many days a year of training. Whether you, as long as you were able-bodied, you had to be there. You had to bring your own weapon. You had to bring your own, at one time, mini balls. You had to have enough powder to shoot 20 mini balls. This was a requirement of everyone that was able-bodied. What's changed? Well, times have changed. However, if we were ever invaded by a ground army, which we probably never will be because of modern technology, however, we still have to defend ourselves against foreign invasions. Maybe this will never happen. Maybe the times have changed to such that missiles and whatever have taken over the era of mini balls and flintlocks and whatever. But it still stands to reason that the right to bear arms was there, and it should always be there. I advise you as political animals to vote for this resolution. If you don't, and I think you're smart enough to realize that the people vote. And those of you that change your mind, shame on you for voting that way to start with.
Question, I must have forgot what to say. Call the roll. Sheriff, would you like to speak?
Obviously, I need to make a comment. I would just ask that, maybe I missed that during the resolution, Mr. Dr. will assume if that's in there. I would just ask that the resolution include specifically Congressman Rowe, our two senators, that they uphold our Second and Fourth Amendment rights. They're the main ones that can change this with the federal government. I just hope that that's included in there, because those are the main ones that need to hear to support our Second and Fourth Amendment right. There's always folks to support them. So I hope that that's in there. That needs to be in there.
Call the roll.
Question?
Question on the motion to support the, I'm sorry, Mr. Street.
That's fine, Mr. Chairman.
Buford Peters,
Aye.
Keith Ritchie, Lawrence Hodge,
Aye.
Nancy Brown,
Aye.
Joel Street,
Aye.
Richard Winters,
Aye.
Ronnie Tribbett,
Aye.
Harry Seas, Charles Montana,
Aye.
Elsie Tester,
Aye.
Steve Lawrence, Tom Bowers,
No.
Joanne Blankenship, Charlie Bayless,
Aye.
Bobby Dees, Ken Arden,
Aye.
Steve Chambers, John Lewis,
Aye.
Sonia Coler, Russell Cott,
Aye.
Scott Sands, Bill Armstrong, Pat Hicks, Robert Goddard.
Sixteen ayes, motion passed. That goes for both sides of the rail.
Mr. Chairman, I would ask that Attorney Bowers submit that to the proper authorities as quickly as possible, because as we speak, federal level, they're discussing this. Senate Judiciary Committee. Turn on C-SPAN, watch it. Times of the essence. It doesn't require any real action on anyone's part other than let us notify our representatives how we feel in Carter County about this issue. Thank you, sir.
Mr. Byers, I make a motion to recess for 10 minutes.
Motion recessed, have a second.
Second.